In 1787, the founding fathers of our country gathered in Philadelphia, Pennsylvania, to write the supreme law of the land, the United States Constitution. In it, they defined our government and how it would serve the people. They established three distinct divisions of government: the executive branch, the legislative branch, and the judicial branch. In this program, we'll take a close look at the makeup and function of one of these three: the judicial branch. In their wisdom, the founders of our country created a system of government that polices itself. That is, each branch has powers of control over the others. It's the duty of the judicial branch to ensure the other branches of government do nothing in conflict with the Constitution. The Supreme Court is the highest court in the land and is the heart of the judicial branch of our government. The words that state the basis for the American judicial system are carved above the front entrance: equal justice under law. The Constitution, in Article 3, established the High Court's position in our government with these simple words: the judicial power of the United States shall be vested in one Supreme Court.
The Supreme Court differs from any other federal court, first, because it's the only federal court that the Constitution itself establishes.
And in such inferior courts as the Congress may from time to time ordain and establish.
Congress has given the power to create and has created all the courts below the Supreme Court of the United States in the federal system. And therefore it could, in theory, abolish those courts. But it didn't create the Supreme Court of the United States, so it can't abolish the Supreme Court of the United States. The Supreme Court of the United States, bearing the judicial power of the United States, is therefore a co-equal branch of government, equal, in theory at least, to the executive branch and to the legislative branch.
The legislative branch makes the laws, the executive branch enforces them, the judicial branch applies and interprets the laws. The federal judicial system is complex, with authority distributed among layers of courts with various purposes, like military matters, international trade, and taxes. Many appeals courts in the system hear cases that come from lower courts, looking for resolution of legal questions. The ultimate authority is the Supreme Court.
Now, the second respect in which the Supreme Court is unique is that it is the highest court in the federal system. It's the ultimate court of appeal in the federal system.
Originally, the Supreme Court was made up of 6 judges. In later years, the number was changed to 9. One of them serves as the Chief Justice of the Supreme Court. The other 8 are called Associate Justices. All are appointed by the President of the United States with the advice and consent of the Senate.
Under our Constitution, the President has the power to appoint federal judges, including the judges of the United States Supreme Court. That presidential power, however, is subject to the power of confirmation in the United States Senate. So when the President appoints a federal judge, the Senate considers that nomination to the court and ultimately has the responsibility of either confirming or not confirming the President's choice.
The term of office for justices on the Supreme Court and all federal judges is actually a term of good behavior, which by and large means life.
And beyond that, Congress is forbidden under the Constitution even from lowering the salary or remuneration of judges, the compensation of judges during their service. This means that Congress is forbidden from retaliating against the judge whose opinions the Congress doesn't like by reducing his pay.
What makes the court so interesting in this is they are probably the best equipped institution to deal with the poor and the powerless, people that have no political voice, have no agenda, have no political power, and the court's best constituent are these individuals.
In 1790, the Supreme Court's first 2 meetings were held in the Royal Exchange Building in New York City. When the nation's capital moved to Philadelphia, the court used Liberty Hall for its meetings, and later moved to Old City Hall. In 1801, the national capital was established in Washington, D.C. The court used rooms in the U.S. Capitol building until receiving its permanent home in 1935, the Supreme Court building. The Constitution describes the Supreme Court's authority in rather brief terms: that it shall have original jurisdiction in cases involving foreign dignitaries, disputes between the states, maritime law, matters that involve the Great Lakes, the oceans and most rivers, treaties with other countries, among other matters of national interest. But for the most part, its duties would be to hear appeals from rulings of lower courts and make final decisions. The brevity of the Constitution's definition of the Supreme Court's role as the third branch of government left to Congress and the court itself the task of filling in much of the details.
At the time the Supreme Court was originally formed, it wasn't really quite sure what the mandate of the court was, what the power of the court was. So it was an organization in search of a mission, if you will.
Service on the court was not seen as a powerful end. In fact, a number of people turned down the job. President Washington appoints a man named Harrison to the court who turns down the offer. John Jay, who leaves the court to go be governor of New York because it was seen as more prestigious to be a state governor than it was to be on the high bench.
That changed very abruptly with John Marshall when he was selected to become Chief Justice.
John Marshall is ordered to be Chief Justice. He's ordered to go on the court. He doesn't really want the job, and Adams orders him as a Federalist to go on. So the court is not seen initially as having a great deal of prestige. It's not a job most people look for.
In George Washington's time, the Supreme Court's original role might not have been impressive. But early in the country's history, several events occurred that transformed the Supreme Court into a major governmental institution. One was the ratification of the Bill of Rights in 1791. In June of 1789, the Bill of Rights was presented to Congress. By 1791, all 13 states had ratified it, making it part of the Constitution. James Madison, who had played a huge role in drafting the Constitution, introduced the Bill of Rights in Congress. In his famous speech, Madison told the Congress why the Bill of Rights was necessary. He said the courts would become the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. Madison's statement implied that the judicial branch would have the power to stop the executive and the legislative branches of government from taking actions that violate the Bill of Rights. The judicial branch, in the role of the defender of the Bill of Rights, has in fact assumed this power.
As a formal matter, the Supreme Court is strictly an interpreter of the laws in the Constitution. It's not meant to be a policymaker. Policymaking is a matter for the Congress and the President. They are the chief actors in the legislative process. The courts are simply meant to interpret the laws made by the Congress and the President and to interpret the Constitution, which the court can't make or manufacture, but which comes to us from the framers and ratifiers of its provisions. However, as true as that is in theory, in practice, the Supreme Court is a policy-making institution. If we look at a range of areas of political life in this country and we ask, how did we get the policies that we have, we would have to conclude that these policies were put in place by the Supreme Court exercising its interpretative authority when it comes to the Constitution and laws enacted by Congress.
In the Federalist Papers, Alexander Hamilton wrote, "The interpretation of the laws is the proper and peculiar province of the courts." He foresaw, long before it was a reality, that the interpretation of the Constitution and the Bill of Rights would be the proper and peculiar province of the U.S. Supreme Court. One of the most important powers of the Supreme Court is its prerogative of judicial review, the power to review and nullify laws or executive actions that conflict with the Constitution. But this was not written into the court's job description. It came about through Marbury versus Madison.
From the very beginning of our republic, there was a dispute about the power of the Supreme Court and the question of the Supreme Court's role in interpreting the Constitution.
Many people believe the court has always had that power, that the Constitution infers it in Article 3.
The Constitution itself, interestingly, does not confer on the Supreme Court or on any court the power to interpret the Constitution and to invalidate or strike down laws that the court judges to be contrary to the Constitution. The court itself assumed that power beginning in the case of Marbury against Madison in 1803.
This case could have been dismissed, but Marshall masterfully, John Marshall, the Chief Justice, uses this case to find a way to interpret what those words mean. Its end result is the stipulation that the court has the power of judicial review, to look again at the actions of every governmental actor, and if they do not comply with the Constitution, to strike them down, to declare them null and void.
In Marbury versus Madison, Marshall effectively said that the Judiciary Act of 1789, a particular section of it, was unconstitutional. And from that, he expounded the ability of the Supreme Court to determine the constitutionality of particular acts of Congress.
On a daily basis, our country's lawmakers must be mindful of the Constitution in carrying out their duties. Congress may pass a law that they feel is constitutional, but if someone files a lawsuit challenging that law and the Supreme Court agrees with the challenge, the law is rejected. But the Supreme Court's power over Congress is not absolute. Congress can rewrite the law so its language conforms to the Constitution, and the Constitution can be amended by Congress. 4 times in American history, Supreme Court decisions have led to constitutional amendments. Likewise, the President may take an action he believes is constitutional, but again, the Supreme Court can declare that action unconstitutional if they rule it's in conflict with the Constitution.
Well, quite a good case can certainly be made that Roosevelt expanded executive power beyond what the Constitution contemplated. And of course, this was the position of the Supreme Court for much of the New Deal until they finally relented and decided to go along with him, or to let him expand federal power, and particularly executive power.
In the United States versus Nixon, the Supreme Court held that Richard Nixon had to turn over the Oval Office tapes, and actually Nixon did so and resigned very shortly thereafter.
Another event that helped establish the Supreme Court's role in government was its decision in the Martin versus Hunter's Laissez case.
Martin versus Hunter's Laissez is a case dealing with basically what happens when state law and federal law conflict. Who wins that dispute?
In these early cases, the courts tended to rule in favor of an interpretation of the Constitution which would make clear that the federal law had supremacy over state law. Now, that didn't mean that the federal government could come in any area and simply displace state law. But where there was an area where the federal government had legitimate jurisdiction, a delegated power from the Constitution to legislate, then its law prevailed over a conflicting state law.
Originally, the country was divided into 13 judicial districts, 1 for each state. Today, there are 96 judicial districts, 13 courts of appeal, and a number of special courts. State courts use state laws as their guide. Federal courts use federal laws and the Constitution. Each state has a court system and its own Supreme Court. Decisions made by lower courts on both the federal and state levels may be appealed upward to higher courts, all the way to the Supreme Court, where the case is heard by the highest authority in the nation. There were 2 additional cases which firmly established federal authority over the states. McCulloch versus Maryland
McCulloch versus Maryland, in my opinion, is the most important Supreme Court decision ever decided. I always tell my students it's my desert island case. If I could only take one case with me to read, it would be this one.
This case involved the question whether the federal government's delegated powers included a power to charter a national bank. And it also raised the question whether the states, if there was to be a national bank, whether the states had any power to tax that bank when it operated within state borders.
And Marshall looks at the issue of Congress's power under Article I, Section 8. Can Congress create a bank? Are they allowed to do that? And what Marshall does is expand the power of Congress beyond just the written word in the Constitution.
And so the Bank of the United States was held to be constitutionally permissible, constitutionally viable. And at the same time, it ruled that states, in this case the state of Maryland, were acting unconstitutionally in violation of the Constitution when they tried to tax that national bank when it operated within their borders.
And Gibbons versus Ogden.
Gibbons versus Ogden is the famous steamboat case in 1824, and it's a case of a state granting a monopoly to regulate the waterways between New York and New Jersey.
Early on in the history of the Republic after the Constitution was ratified, questions began to arise about the relative authority of the states and the federal government. The Constitution was an interesting one because while not displacing state power, it created a federal government that shared power with the states. And of course the boundary line issues became the interesting ones. Where was the boundary of federal and state power?
Again, Marshall, a strong federalist, defines the power of the federal government as broad as he can. And he says commerce is basically anything that moves from place to place. And hence the states can't get involved there if the federal government has the power to regulate that commerce area.
And that was the essential message of the early federalism decisions as handed down by the great Chief Justice John Marshall. Happened to be the fourth Chief Justice, but was really the architect of the Supreme Court as we know it, the person who built the court as a prestigious institution and someone who was instrumental in establishing the ground and significance and scope of federal power.
Court cases are the means by which the judicial branch of government exercises its authority. During our country's history, several landmark cases have challenged the freedoms set down in the Bill of Rights. Here are some of the more important Supreme Court decisions which have helped further define and protect the rights of individuals.
Schenck is important because of Oliver Wendell Holmes, who creates what's called the clear and present danger test. His example that he uses in Schenck is that you can't yell fire in a crowded theater. And the argument he's trying to make is that even the word fire is not protected in the context and in the environment of the action that would result by yelling it in a theater. And by 1969 in Brandenburg versus Ohio, the court creates a test for those who have really speech we don't want to hear, speech we hate, speech that most of us find to be reprehensive, most of us find it to be obnoxious. Brandenburg versus Ohio is a case involving the Ku Klux Klan. And the court creates a four-part test. All parts have to be present in order to claim that this person's advocacy is not lawful.
The most dangerous thing is to tell someone what they can say and what they can't say in a free society. Ultimately, views of the Nazi Party or any other party will stand or fall based upon people's acceptance of it. And when you censor it and say, well, you can't say this or you can't say that, what you've done, in effect, is really short-circuit a true and full democratic process.
Skokie versus Illinois is a case that does not go to the high court, but it's a good example of the courts in general supporting the ideas of minority beliefs, of speech that, again, is a minority view.
Skokie was an enormously difficult case. It was enormously difficult because why did the Nazis have to march in Skokie.
The court here rules in favor of the Neo-Nazi Party of America and allows them to march in the town of Skokie, Illinois, a town full of Holocaust survivors.
I mean, it was one thing to have them march in Chicago, but they were marching in Skokie, and the reason they were marching in Skokie is precisely because it was a heavily Jewish area where a lot of former Nazi survivors, concentration camp survivors, happened to live.
And again, the argument that the First Amendment allows that the speech protects that minority viewpoint.
The Supreme Court ruled in Texas v. Johnson that it was unconstitutional to ban burning the flag. And this was a very important civil liberties case because it held that your ability to express particular viewpoints, even if they are contrary to the popular notions, and even if, in a sense, they desecrate national symbols, should be protected.
One decision of the Supreme Court that caused a great deal of concern on Capitol Hill and throughout the country was the Supreme Court's decision finding that the First Amendment protects individuals who physically desecrate and destroy the flag of the United States. And since then, there's been an ongoing effort to amend the United States Constitution to make clear that it does not protect individuals who would desecrate our national symbol.
In 1954, the Supreme Court handed down what was then a very controversial decision in Brown v. Board of Education, ordering the desegregation of public schools in the South, where schooling was segregated by race.
The decision of the Supreme Court in Brown v. Board of Education in 1954 was one of the most important decisions the Supreme Court ever made, because that decision meant the ultimate end of segregation in the public school system. And that was a big step toward overcoming the legacy of slavery that persisted in the system of segregation.
So that's a decision that began as a very controversial one, but eventually became considered to be not controversial, to be plainly the right decision. And it's hard to find anybody today who's critical of the outcome in Brown v. Board of Education. Some people think the court didn't use quite the right reasoning to reach that outcome. But almost everybody, almost all commentators, lawyers, and jurists agree that the decision was the right decision. There was a famous case of the University of California against Bakke, in which the court seemed to end up with a kind of middle position, saying that a certain kind of preferential treatment under some circumstances was constitutionally permissible, even though it favored one race, that is minority, members of minority races, over others.
In the Bakke decision, the Supreme Court decided that race could indeed be a factor in making decisions about admissions to higher educational institutions.
Well, is that reverse discrimination, and is that reverse discrimination itself unconstitutional?
There's been a great deal of controversy over the Bakke decision, and there are other more recent decisions of the Supreme Court that would lead one to question whether the Bakke decision is still good law.
Baker versus Carr is an interesting case to look at, and I think one thing that adds to its interest is Chief Justice Earl Warren, after his retirement, was asked at one point, what was the most important decision during your tenure as Chief Justice? And this is a man who was on the court when Brown versus Board comes down, when Miranda, Escobedo, all of these major decisions. And he said Baker versus Carr by far was the most important. The argument that the equity at the voting booth, that each of us, our vote, one man, one vote, meaning one person, one vote, our votes are worth the same amount in the sense of gerrymandering and drawing districts where certain votes are diluted or not. Warren saw that as absolutely essential to the democratic process, that each of us at the voting booth had the same amount of political power.
The Miranda decision of the Supreme Court was an important case in which the Supreme Court imposed on the police certain responsibilities in informing a criminal defendant of that defendant's rights under the law.
Shortly after Miranda versus Arizona is written in 1966, by 1968, Congress passes the Omnibus Crime Control Act, which argues that confessions that are wholly voluntary don't require Miranda. In other words, some attempt to cut back on the import of Miranda.
Well, the Supreme Court has essentially reaffirmed the decision of Roe versus Wade, which established a constitutional right to abortion.
Well, that's an extremely controversial case. Is there a good argument for it? Well, many people think that Justice Blackmun didn't make an argument at all. He just declared it as a matter of judicial fiat that abortion was a constitutional right. And then what about the rights of the unborn? Were their rights simply trampled on by the court in declaring a right to abortion?
On the issue of abortion and pro-choice and pro-life parties that bring issues to the court, this court really has sent the signal that they'd rather have the states deal with it, that the state legislatures should write statutes and state courts should rule on those. The key seems to be, at least the person that seems to be the key to all this, is Justice O'Connor, who seems to argue that regulating abortion is permissible as long as the burdens on a woman's right to have an abortion are not what she calls undue. The problem is determining what undue means, and we don't have a lot of indication what that means by her. Only several times has she explained what that means. So the information is scant, but the court's test is an interesting one. They'll allow regulation, even a lot of it, just as long as the burden, that there is still some access to the right to an abortion. Burden can be there, it just can't be an undue one. Sometimes also included is, believe it or not, Dred Scott, to show how the court can go too far, that the court, when it enters the political thicket and can actually find itself imperiling the nation. I mean, many believe that the Civil War was prompted even further by the court, that they add fuel to the fire, they don't stop it.
Another sad chapter in our history involved the Dred Scott decision in the years leading up to the Civil War. And in that case, the Supreme Court of the United States essentially denied the humanity of slaves and denied the ability of slaves to be persons and citizens under our Constitution. That was a sad day for the Supreme Court of the United States, and it took the Civil War to overcome the harm that was caused by that decision.
Occasionally, we sometimes put together a list of the worst of Supreme Court justices, and usually Tawney heads the list solely because of Dred Scott and the effects and the aftermath of that.
Oh, I think Tawney's been much maligned in history, actually. If you look at him down the road in a famous case called Cooley versus Board of Port Wardens and others, Tawney was not the racist, state rightist that people see him as. But of course, history always remembers him for Dred Scott. I mean, that is his, earmark, whether he likes it or not.
Being appointed to the Supreme Court is a high honor. These 9 individuals have a rare mix of good family background, fine education, valuable experience, wisdom, and luck. Luck meaning being in the right place at the right time, and of the proper political persuasion to make a good presidential appointment. In order of seniority, the present Supreme Court is made up of the following 9 jurists. William Rehnquist, born in 1924 in Milwaukee, Wisconsin. Educated at Stanford and Harvard. Appointed to the High Court by Richard Nixon in 1972. Promoted to Chief Justice by Ronald Reagan in 1986. Justice John Paul Stevens, born in 1920 in Chicago, Illinois, a graduate of the University of Chicago and Northwestern. Nominated to the Supreme Court in 1975 by Gerald Ford. Justice Sandra Day O'Connor, born in El Paso, Texas in 1930. Her alma mater is Stanford, and she was named to the court by Ronald Reagan in 1981. Justice Antonin Scalia, a native of New Jersey, born in Trenton in 1936. He studied at Georgetown University, the University of Fribourg in Switzerland, and Harvard, nominated to the Supreme Court in 1986 by Ronald Reagan. Justice Anthony Kennedy of Sacramento, California. He was born in 1936, educated at Stanford and Harvard. He was appointed in 1988 by Ronald Reagan. Justice David Souter, born 1939 in Massachusetts, studied at Harvard and Oxford. He was named to the High Court in 1990 by George Bush. Justice Clarence Thomas of Georgia, born in 1948, educated at Holy Cross College and Yale. He was nominated in 1991 by George Bush. Justice Ruth Bader Ginsburg, born 1933 in Brooklyn, New York, educated at Cornell, Harvard, and Columbia University, named to the High Court in 1993 by Bill Clinton. Justice Stephen Breyer, a native of San Francisco, California, born in 1938, he is a graduate of Stanford, Oxford, and Harvard. He is the junior member of the court, appointed by Bill Clinton in 1994. The only way to remove a Supreme Court justice from office against his will is by impeachment, the same way a president or a cabinet member is removed. To impeach a justice, the House of Representatives must present charges against him or her, and then the Senate must try the charges and vote for removal by a 2/3 vote. Samuel Chase, a signer of the Declaration of Independence, is the only Supreme Court justice ever impeached. This occurred in 1804, when the House charged him with using his judicial position to make political speeches against President Thomas Jefferson.
Chase was a very fiercely partisan political person, and his political opponents resented that partisanship and believed that it was incompatible with his service on the bench as a justice. And so impeachment proceedings were brought.
In fact, the Senate refuses to convict him, mainly because it was seen as so political. And never again is the justice ever brought forward on charges of their political views to be impeached.
It's certainly true that presidents very often look to the political or ideological or philosophical views of judges in making their appointments. Presidents will want judges to be in office, including preeminently Supreme Court justices, to be in office, who will look at political life and the Constitution the way the president does.
Thurgood Marshall was the first African-American named to the Supreme Court. Lyndon Johnson appointed him to the court in 1967. He served until 1991. In 1954, while serving as an attorney for the NAACP, Marshall argued the landmark case Brown versus Board of Education before the Supreme Court. In 1982, the Supreme Court got its first female justice, Sandra Day O'Connor. President Ronald Reagan appointed her, breaking a 192-year-old men-only tradition.
One of the great heroes who served on the Supreme Court was Justice John Marshall. Justice Marshall was the fourth Chief Justice of the United States, but he helped shape the role of the Supreme Court and help establish the Supreme Court as one of the very important institutions of our government.
More recently, there's been Justice Felix Frankfurter. Justice Frankfurter was an extremely well-respected Harvard Law School professor. And it's funny because on the court, he actually became somewhat more cautious and conservative than as a law professor, but a great and agile legal mind, and certainly someone to admire.
William Howard Taft was a very interesting member of the Supreme Court. He was the only member of the Supreme Court who also served as President of the United States. He actually became Chief Justice of the United States after he had served as the President. And he believed that his work on the court was the hardest work he had ever done. And being the Chief Justice of the United States fulfilled his ambitions in a way that being President had not.
Probably my hero of all is got to be Oliver Wendell Holmes. Holmes served on the court for 30 years, was known as prophetic. The great dissenter, known that not for the volume of his dissents, but for the import of them. Many of Holmes' dissents turn around and become majority opinions decades later.
Every year, 4,000 to 5,000 cases are appealed to the Supreme Court. Only those bearing on the most important issues are heard, usually about 150. At least 4 justices must agree on a case before it's put on the court's calendar. The Supreme Court's regular session is called the October term. It begins the first Monday in October and ends in June the following year. After the regular term, the Supreme Court may hold a special session only when urgent matters arise that can't wait until the next regular term. For example, the court had to hold a special session to hear the U.S. versus Nixon case. In that case, it unanimously decided to order President Richard Nixon to release Watergate-related documents. The Supreme Court is the most traditional branch of the government, with its curiously old-fashioned and time-honored traditions, such as the use of quill pens made from goose feathers. When the justices begin a conference, they first shake hands with each other to symbolize their harmony of purpose. In court or in written opinions, they address the others as "my brothers" or "my dissenting brothers." Secrecy is one of the oldest and perhaps the most practical court tradition, because disclosure of conference proceedings could lower the public's regard for the court and its decisions.
The deliberations of the Supreme Court are deliberations that take place in private. The members of the court meet to discuss their cases and deliberate, to argue with one another and to try to convince one another of the merits of their respective positions.
To start the conference, the Chief Justice calls the first case to be decided. By tradition, each justice speaks in order. The Chief Justice first, followed by the justice who has served in the court the longest, then the next longest, and so forth. The least senior associate justice speaks last. To decide a case, the court must have a majority vote. If all justices are present, a majority would be 5 votes.
When the court reaches a decision on a case, the court issues an opinion in which that decision is announced, and the rationale for the decision is explained. It is also frequently the case that there are dissenting opinions that are issued at the same time, in which the judges who were not in the majority who decided the case will explain why they disagree with the decision that was reached by the majority of the court.
The judicial branch of government and the role the Supreme Court plays in upholding the Constitution is crucial to democracy and the strength of our country. The three branches of government complement each other in a system that holds freedom as its highest virtue. It's the judicial branch that guarantees equal justice under law.